Hello, good afternoon, and welcome to 10 Years Since Shelby County, How Democracy Advocates Can Fight Back. I'm Manal Haddad, Senior Communications Manager for Voting Rights and Redistricting here at CLC. Thank you so much for joining us today. CLC is a national nonpartisan organization that works to advance democracy through law at the federal, state, and local levels. We fight for every American's right to participate in the democratic process, and we believe our democracy should be transparent, accountable, and inclusive. The Supreme Court has made a series of anti-democratic decisions in the last decade, including Shelby County v. Holder, which eviscerated Section 5 of the Voting Rights Act by gutting the incredibly important preclearance process. Preclearance dramatically transformed the freedom to vote for Black voters in the South by requiring states and localities with a history of racial discrimination to get voting law changes cleared by the Department of Justice or a 3-judge federal court panel before going into effect. Shelby County v. Holder was decided 10 years ago, but it continues to restrict Black voters' freedom to vote to this day. While the Supreme Court's recent ruling in Allen v. Milligan, which upheld the validity of Section 2 of the Voting Rights Act, is heartening, there is still a long way to go to achieve the promise of a fully equal, inclusive, and accessible democracy. Today, CLC's panel of experts will discuss how Shelby County v. Holder and Allen v. Milligan have impacted access to democracy and examine the fringe independent state legislature theory that was at the heart of the recently decided Moore v. Harper case. Now, I would like to turn it over to our moderator for today, Gilda Daniels, a voting rights consultant at Campaign Legal Center, professor of law at the University of Baltimore School of Law, and former deputy chief of the voting section of the Civil Rights Division at the U.S. Department of Justice.
Thank you, Manal. Before we start our discussion, I'd like to go over a few housekeeping items. During the conversation, please use the comment section on Facebook or YouTube to submit your questions for members of the panel. At the end of the panel, we will start the question and answer section. We will do our best to get to each question, but in the interest of time, we may not be able to answer every question. If we are not able to answer your question today and you are a member of the press, please email your questions to media@campaignlegalcenter.org. If you're a member of the public, please email info @campaignlegalcenter.org. Now I'd like to introduce today's panel. Paul Smith is a senior vice president at Campaign Legal Center, and he's argued before the United States Supreme Court 21 times, securing many victories, including Lawrence v. Texas, the landmark gay rights case. Paul has also argued several voting rights and redistricting cases at the court, including Gill v. Whitford and Lulac v. Perry, which involve partisan gerrymandering and mid-cycle redistricting. Next, I'd like to welcome Mark Gaver, who is Senior Director of Redistricting at Campaign Legal Center. Mark leads CLC's redistricting litigation and policy program and has served as counsel in major federal and state redistricting cases over the past 10 years. We also welcome Kevin P. Hancock, who litigates to protect voting rights, ensure fair redistricting, and to reform the campaign finance system at Campaign Legal Center. Kevin served for nearly a decade in several capacities as an attorney at the Federal Election Commission, and before joining CLC, represented the executive branch as a trial attorney in the Federal Programs Branch of the U.S. Department of Justice. Thank you to the members of the panel for joining us today for what I'm sure will be a very interesting conversation. Paul, I'm going to start with you. This past Sunday marked the 10-year anniversary of Shelby County versus Holder, which has certainly had a significant impact on the voting rights landscape. Can we talk about what trends you've seen, certainly in the wake of the Shelby County decision, and how the Shelby County continue to impact voters today?
Happy to, Gilda. I have to say, Shelby County really has to rank as one of the worst voting rights decisions that the Supreme Court has ever issued. And that's saying a lot, frankly. But 10 years ago, the majority of the justices arrived at the view that it was no longer justified to put this preclearance mechanism as a burden on those covered jurisdictions, principally the states of the Deep South. Basically, they said, well, we think times have changed in the South, and we don't think they have any real reason to think they'll resurrect all their anti-voting practices that existed back when the act was passed in the 1960s. That, of course, proved to be utterly false. The day after Shelby invalidated the preclearance mechanism, states like North Carolina and Texas and Georgia set about trying to deter voting by voters of color. They looked around and they said, look, in the Obama era, black people are voting as much as white people in our states, and we don't want to keep it that way. And so new voter ID laws, getting rid of Sunday voting, and all kinds of stuff started showing up on the voting landscape. And because there was no more preclearance, the only remedy has been either a Voting Rights Act lawsuit or a constitutional lawsuit, neither of which is very easy to win. With the court we have, the Supreme Court has simultaneously made those harder to win as well. And so what we have is a lot more freedom for the discriminators to bend the law against African Americans and other people of color in jurisdictions that until 10 years ago couldn't have gotten away with it.
And certainly it's given us fewer tools to work with, certainly as voting rights advocates. And we think we dodged a bullet recently, certainly with the Allen v. Milligan case. Many called it a surprising decision. I was actually relieved as opposed to shocked or surprised. And certainly the Shelby County decision was certainly involved Section 5 of the Voting Rights Act. And we have the Allen v. Milligan case, which involved Section 2. Mark, I'm coming to you. So what do you think was the significance of that decision? And certainly, what was your initial reaction to it?
Well, I think it's incredibly significant for minority protections in redistricting and having representation in Congress and state legislatures and local governments. I think I was maybe a little bit more optimistic than some people, but I was in the middle of two Section 2 redistricting trials and like one day of non-trial between the two. And when the decision came down in the morning and I woke up and turned over and saw the phone and literally said to myself, am I actually awake? Did what this says happen? So it was incredibly relieving, as you said. It means that there will continue to be representation for Black voters and Latino voters, Native American voters across the country, whether that's in Congress or in state legislatures or at the local level. And immediately, what we will see is an improved set of representation for Black voters in Alabama, and Louisiana, and likely in Georgia as well at the congressional level, because of pending cases in those states. And so, while we should expect that decades of precedent would be upheld by the Supreme Court, I think that many of us were worried that might not be the case. And the one tool that we had left to enforce those protections might slip away or become essentially meaningless. And that did not happen, gratefully. And I think as a result, it actually has strengthened the protections of the Voting Rights Act by having this reaffirmation from the Supreme Court that the law as it was is on the books and should be enforced by courts across the country.
Sometimes maintaining the status quo is a great victory, even if it's around for 40 years, because I will sign up for I was totally stunned. I didn't see this coming. The court had such a long record of trying to say, we believe in colorblindness. We don't believe in anything that affirmatively helps people get representation. So, but that's not the position of the court now. Chief Justice Roberts, joined by Justice Kavanaugh, have said affirmatively requiring the creation of districts that make it possible for people in a deep southern jurisdiction or another jurisdiction with racial polarization to get representation is fine. In fact, it's the law. It's amazing.
Right. We were all shocked that the Supreme Court actually followed the law. Followed the law, right? 40 years of precedent. Kevin, you wanted to jump in?
Sure. Yeah, I was just going to echo that I also found it extremely surprising, particularly given Chief Justice Roberts' previous opinions in other contexts, advocating strongly for a colorblind constitution, particularly in the affirmative action context. And many observers have noted that the Supreme Court is about to make a major decision in the affirmative action context. And so it will really be interesting to see what happens in that ruling and to compare to what occurred here. But, thankfully, the chief and the majority here came out in the right way.
It will be very interesting, and we are all watching and waiting. But something that wasn't surprising certainly was Justice Thomas's almost, maybe it was surprising in how long it was, almost 50 pages of a dissent, certainly where he argued that that essentially the Voting Rights Act is race neutral, that we should be using race neutral benchmarks as opposed to race conscious ones. Paul, I'm coming back to you. So what do you make of this? Certainly, we can talk about his dissent, but also there certainly was a trend towards race neutral, a race neutral approach to voting rights.
Right. No, that's the orthodox conservative position on the Supreme Court, is that the 14th Amendment doesn't require that you do any, the Congress doesn't even allow Congress to create mechanisms to create affirmative equality by bringing people up. It simply says you shouldn't think of race at all, that you should be colorblind. And, that's historically inaccurate, as Justice Jackson has pointed out in oral argument. But it's also very harmful. I mean, if you have a state where there's really massive polarization in voting between whites and blacks, as there is in the Deep South, not everywhere in this country, but in the South, and you allow and you pay no attention to race, then you end up with 100% of the delegation going to Congress being the candidates of choice of white voters. And that is not what the Voting Rights Act says, and it's not what it should be understood to say. I mean, Justice Thomas is so against the idea of creating districts for minority representation that he even adopted a position which really is ludicrous, which is the idea that Section 2 of the Voting Rights Act doesn't apply to redistricting at all, even though the provision we're talking about was passed solely to overcome a Supreme Court decision about redistricting. And so, but this is a position he's held a long time. He really has a strong view that we should simply ignore race in this country and everything will be fine.
And if I can, I would add that, it's like, obviously the dissent is extremely troubling for the reasons Paul detailed. I'm also extremely troubled by Justice Kavanaugh's concurrence. I mean, where he effectively says, okay, like, I agree with the majority that Section 2 in this context is constitutional, but, I'm going to leave open, and he's essentially inviting the argument that perhaps the argument could be made that based upon the passage of time since 1982, that maybe Section 2 could become unconstitutional given changed conditions, and that Alabama somehow didn't make a very good argument on this point. Again, effectively inviting an argument on this. And given that the ruling was only 5-4 and that Kavanaugh's vote was needed for the majority, I find that incredibly troubling for the future.
Right. Certainly. He's kind of highlighting. Certainly, I'm with you on this one, but the next one, I can't promise you. I can't promise you that I'll stay with you. So certainly, we have this Allen v. Milligan, I guess, relief or shock or surprise, but certainly happy that we had the result, certainly in the Allen v. Milligan case. But another Section 2 case, certainly where the Supreme Court actually weakened Section 2 was the Brnovich versus DNC. And it certainly is a case that presents challenges for advocates in bringing Section 2 cases. And so when we're looking at certainly what we can foresee, certainly in regards for democracy advocates facing what we might face when it comes to Section 2 of the Voting Rights Act, I think we're certainly looking at, we already saw that the Supreme Court addressed the private right of action argument. And certainly the lower court in the Allen v. Milligan case addressed the private right of action and rejected it. But we see there's still courts that are entertaining these ideas, and that they are finding judges that are willing to listen. I mean, the fact that certainly some of the issues that were in the Allen v. Milligan case actually made it to the Supreme Court is troubling. But now in this Brnovich, certainly we're seeing that certainly anti-democratic advocates have no problem with presenting these claims. And that judges are unfortunately amenable to hearing about them. So, what do you think about certainly some of the challenges that we can anticipate? Some of the
what we have is kind of a double standard under Section 2 now. The Brnovich case is about things like laws that disparately burden voting, make it harder for African Americans or Latinos or Native Americans to vote compared to white people. And what the court did there is they came up with a lot of rules that don't seem to have any basis in the statute that make it if not impossible, really, really difficult to win a claim like that under Section 2. And on the other hand, in the redistricting context, we have an opinion from Chief Justice Roberts in the case just the other day that pretty much down the line keeps the law that's been in place since the 1980s and strongly reaffirms, I think, the idea that we're going to continue to require states to, where necessary, create minority representation opportunities. So why that double standard makes sense, I don't know, but at least we got the part that's important to Mark as a redistricting lawyer. He has cases left to litigate all summer.
Mark?
Yeah, that's definitely true, and we are in the middle of litigating them.
And and it's not just in the Deep South that this applies. Mark's doing a case in Washington State. He's doing a case involving Latinos in Washington State, involving Native Americans in North Dakota. We had a big case involving all three groups: Asians, African Americans, and Latinos in Virginia Beach. So the problem isn't just in the South, deepest of the South, but it's in many ways the most severe.
So, Paul, you mentioned other redistricting work, and we know that CLC works to make sure the redistricting process is certainly fair and transparent, is as fair and transparent as possible. And one way to do that is through litigation. So, Mark, certainly, what do you think? Will you think the Milligan case, will that decision impact any of CLC's ongoing litigation? You mentioned the two cases that you were actually in the middle of. Certainly, are there other cases that could be impacted?
Yeah, so immediately, it's very beneficial to those two cases, the Washington and the North Dakota case that Paul just mentioned. We immediately started citing it to the court during the trial in the North Dakota case, and actually, the decision got rid of several arguments that the lawyers for North Dakota had advanced, and some of the arguments that their expert witness had advanced by declaring those things to be irrelevant to. For example, one argument was that our proposed plan in North Dakota, our demonstration district, did not retain a sufficient amount of the core of the prior district. And the Supreme Court in Milligan said, whether or not you've maintained your prior discriminatory plan in your new one is not really what Section 2 is aimed at. So it was helpful immediately in that regard. We have a trial coming up in Galveston County, Texas, in August about the elimination of a longtime Black and Latino majority commissioner court district there. It will be tremendously helpful in that case as well. And I think it also, beyond just the litigation that we affirmatively bring, and perhaps most importantly, it tells states when they're developing these plans that they don't get to act as though the court is not going to enforce this law. And so I think we're likely to see more compliant plans at the outset, in addition to having the ability to challenge ones that aren't.
I might just throw in a comment, Gilda, about where did this come from? I mean, this doesn't look like the John Roberts we've been reading for the last 20 years. And I guess you do sort of wonder whether all the pressure on the court to stop being really extreme and one-sided and conservative that followed on Dobbs last year was what motivated he and Justice Kavanaugh to find a way to maintain the status quo and keep Section 2 a viable remedy for redistricting, instead of sending another message to the country that they were taking this really important provision of federal law down. It's just an interesting thing, and that the Roberts Kavanaugh grouping does look very separate now from the really conservative justices Alito, Gorsuch, and Thomas.
I mean, perhaps he, having said in Shelby County that Section 2 remained the law of the land applied nationwide, and maybe he realized that if just 10 years later he undid that, that would look a little double, I don't know what the right word is, but ironic at the least. I will say, Justice Kavanaugh was on the DC Circuit, and I believe sat on at least one 3-judge court hearing a Section 5 challenge, and sided, with the parties that were saying that the plan should not be pre-cleared. And so I think he has some experience seeing at the local, at a local level. This was about a school district. At the local level, the harm that can happen if we don't have strong protections under the VRA. So perhaps that aided in pulling him across the line.
Kevin, you wanted to comment?
Sure. Just another quick thought about the Chief Justice. He is kind of notoriously concerned with how the court looks, and that was definitely evident from his Dobbs opinion. And so this is Milligan's a huge win. The Moore v. Harper case, which we'll talk about in a moment, is a big win for democracy. I do think that there is a little bit of a danger, though, in giving the court a little bit too much credit when it comes to these cases, because it is, they are entertaining what should be fringe and extreme and somewhat crazy theories, and then being congratulated for rejecting them and get to take credit for looking reasonable in doing so. And I think it's important to keep in mind that, a more moderate court probably wouldn't entertain some of these theories in the first place.
Absolutely. There are a number of theories about why Roberts taking these positions, not only in this Milligan case, but also in the Moore v. Harper case, which we'll get to next. And so, and a lot of it has to do, a lot of the theories have to do with the impact of Dobbs. So we'll see if this continues, because again, we still have yet another case we're waiting for, the affirmative action case in education, and we're just waiting to see if they'll drop that one and leave for vacation and leave us with the remnants of affirmative action. We shall see. But so yesterday, certainly the Supreme Court weighed in on the Moore v. Harper case, which certainly deals with this dangerous and fringe, certainly was or is a fringe theory, the independent state legislative theory. And I was certainly in one situation where someone called it a doctrine. It's like, no, it is not a doctrine. It is a theory. And certainly the court, I don't know if hopefully this wasn't a surprise, since people were so surprised with Milligan, but certainly, thankfully, they rejected the independent state legislature theory. So, Kevin, can you explain certainly why that theory would have been dangerous, and certainly what the Supreme Court's decision will mean for voters?
Sure. Yeah, I'd be happy to. So I guess first I'll start off by kind of explaining what it is. And it's important to know that the Constitution grants primary authority for regulating congressional elections to the states. And that the relevant provision of the Constitution, the Elections Clause, uses the word legislature. And so those proponents of this theory, not doctrine, as you said, theory, have argued that, well, given the use of the word legislature, what that means is that when it comes to the state's power to regulate federal elections, that power resides only with the legislature, to the exclusion of any other state body, including the state courts. And so a state court, as in this case, could not strike down what the legislature does in terms of regulating federal elections, whether it be the maps at issue in Moore or any other federal election rules, cannot strike that down using provisions in the state constitution. And so in Moore, what happened was the state Supreme Court of North Carolina said, hey, this partisan gerrymander map enacted by the state legislature violates our Constitution's protection for free and fair elections and other provisions as well. And the proponents of this independent state legislature theory said, well, the state court had no right to weigh in at all on whether it was constitutional. The legislature gets to do what it wants. And so there's a few reasons why that's so dangerous. So first, if it had been adopted by the Supreme Court, it would have unleashed state politicians to just violate state voters' rights at will without any checks or balances from other entities in the state government, including the courts. It could have threatened the existence going forward of independent redistricting commissions. And I know Mark is going to talk a lot more about those in a little bit. And importantly, it would have eliminated the ability of victims of partisan gerrymandering to challenge these gerrymanders in any court. The Supreme Court's already held that you can't challenge them in federal court. And that was an opinion a few years ago in Rucho. Had they adopted this theory, that would have closed the state courthouse doors as well to challenging partisan gerrymanders. So it's incredibly important that this theory was rejected.
Absolutely. Anyone else want to chime in on Moore versus Harper?
This was another case where the Chief Justice may have wanted to maintain a position that he mentioned in a prior case. In Rucho, the partisan gerrymandering case, where they said federal courts aren't going to be able to hear these cases anymore, back a couple of years ago, the chief wrote an opinion that said, "But you can always go to state court and make state constitutional arguments." It would have looked pretty hollow just a couple, 3 years later for them to say, "Oh, by the way, you can't go to state court either because they're not allowed, at least as to congressional maps, to have a point of view." And so what's really interesting about the way he wrote it is not only did he say you can go to state court and try to get them to hold something unconstitutional as a partisan gerrymander, but the people, if they can get something on the ballot, can actually pass an independent commission, and that's fine too, for as far as I can tell. Even though his prior view had been it violates the elections clause because it says legislature, it doesn't say commission. So it's an interesting shift toward a more moderate position in both of these cases, by the chief, by Kavanaugh, and in this case also by Barrett. That she's going to be an interesting person to watch, the newest justice, who does occasionally show signs of trying to help create a middle where they can build a bridge to the other ideological side of the court.
It's very interested in where she landed, certainly in the Milligan case. She is definitely someone to watch. And so, in talking about the independent state legislature theory, certainly one of the things that was impacted was independent redistricting commissions. And so we've talked a lot about the challenges democracy advocates are facing. So it's probably time to talk about some innovative solutions. And certainly something that's gained a lot of popularity are independent redistricting commissions, also known as IRCs. And so, Mark, can you explain how IRCs can help prevent gerrymandering and racial vote dilution?
Yes, absolutely. So I think so everyone is supposed to not be involved in racial vote dilution, right? But independent redistricting commissions, I think the main benefit is stopping the partisan gerrymandering from occurring, and I think we saw that pretty successfully this redistricting cycle in the state of Michigan, which in 2018 the voters adopted by a ballot measure. True Citizens, Independent Citizens Redistricting Commission, with a cross section of normal citizens who, I think like 9,000 people or something applied to be commissioners from across the state, and that was whittled down to a smaller group, 15, I think maybe, or something like that, of commissioners who were both, covered both major political parties and unaffiliated voters. And we saw a very serious, transparent process where there were multiple hearings held across the state, virtually and in person, where you saw that feedback from the community and from folks talking about communities of interest was truly listened to, and map drawing occurred, as in front of people transparently. And so, and coupled with strong standards in the law that prohibited partisan gerrymandering and required that the maps be checked to ensure that they were not, having an unintended disproportionate benefit to one party or the other. And so overall, we saw just an incredibly improved process in Michigan. CLC at the time was comparing it to its state across my home state, the state across the lake, Wisconsin, which was just the sort of 180 of the Michigan process, and had no plan that was able to be agreed upon between the legislature and the governor, and was made its way to the Supreme Court, and really was just a mess. And so we saw Michigan, we see states like Colorado and California and Arizona all have significantly improved processes with these commissions than what you see certainly when it's the legislature. And also, I would say significant improvement when there's citizen commissions, compared to the states that have politicians on bipartisan commissions. And so we saw in Virginia sort of the inability of those people to come to an agreement, with the map ending up in front of the state Supreme Court with two special masters drawing it. The end result appears to be good, but in terms of process, you'd much rather see the kind of transparent process in Michigan than having two experts drawing the map, kind of in front of their computer behind closed doors. And so there really is the potential to curb partisan gerrymandering by having these independent citizen commissions. And, just as the legislature is bound by following the VRA as well, so are they. And in fact, probably better in most cases with the citizens commissions, in that you see them hiring actual respected consultants to do the analysis, as opposed to the legislature kind of taking a stab in the dark.
I mean, the IRCs is a great solution for partisan gerrymandering while protecting voting rights of minority citizens. The difficulty is that, especially in the states east of the Mississippi, it's very hard to get a constitutional amendment to take the power to gerrymander away from the legislature on the ballot. You basically have to pass the bill through the legislature to get it on the ballot. And so it's not a realistic option in most of the states, at least half, maybe a little more than half of the states. Mm-hmm. This is a reform you see in Western states that have the progressive reform of allowing citizens initiatives to get things on the ballot. And where that exists, we very much encourage citizens to get together and follow the lead of those states that have this. It's a much, much better system.
Absolutely. Ranked choice voting is also something that folk are trying to using certainly to curtail certainly combat the independent state legislature issues as well, and certainly work towards redistricting, helping the redistricting process. So we've talked a lot about the Supreme Court, and we certainly will continue to, but we haven't had any conversation about Congress and what it can do to help certainly help voting rights advocates. And we've certainly seen that despite calls for action, Congress has failed to pass legislation that protects the freedom to vote. We've seen the John Lewis Voting Rights Advancement Act get presented to the Congress session after session, and it has failed to pass. So in the absence of federal legislation, what do you think can be done at the state level? And we can also talk about whether or not there's what the possibilities are, certainly for the passage of federal legislation, but also there's work being done on the state level to address this issue, and certainly to protect voters and helping to ensure that certainly every voice is heard in our democracy. Kevin, do you have comments?
Yeah, Gilda. So definitely, you are absolutely right about the need for federal legislation. It is sorely needed, and we do need the John Lewis Voting Rights Advancement Act. And the reason for that is a voter's freedom to vote. That should be protected regardless of what state they live in. So it shouldn't depend upon whether you happen to live in a state that values the freedom to vote in an inclusive way or not. And so that's why federal legislation is so important. But as you noted, there are significant roadblocks to that now. And so that does raise the question, what can be done at the state level? And there are a few things. I mean, so independent redistricting commissions are an important state level reform and mechanism for instituting fair maps. State litigation, of course, and given the Moore v. Harper ruling, that still keeps the door open for groups like CLC and others of our allies to continue asking state courts to strike down anti-voter laws and unfair maps that violate state constitutional rights. And again, that door continues now to be open in light of the Moore v. Harper ruling. And finally, another important aspect is states can pass their own voting rights acts, and many have done so in light of the Supreme Court's rulings over the last decade, consistently undermining the Federal Voting Rights Act. So currently 6 states have adopted their own voting rights acts. And just last week, Michigan introduced its own Voting Rights Act as well. So there does seem to be momentum at the state level for this reform. And, state voting rights acts have a number of advantages. states in crafting these laws can make it easier for plaintiffs to prove violations in the way they structure the law, easier than it is at the federal level. They can give minority communities a greater voice in the judicial process and crafting remedies, rather than deferring to the proposed solutions of self-interested politicians, which is what happens so often now at the federal level. And many states have chosen to institute preclearance. So similar to Section 5, which was struck down in Shelby County at the federal level, states are free to institute preclearance at a state and local level as they see fit, and many states have done just that.
Let me just get back to Congress for a minute, though. I mean, as Kevin pointed out, your right to vote shouldn't depend on where you live and which state you live in. And what we see is voting rights acts are great in those blue states where they're being passed, but in the places where the problems with voting are the worst, Congress is the only institution that can be a check on the Supreme Court. The framers believed in checks and balances, and just as state courts should check state legislatures, the Congress needs to check a Supreme Court that is less than enthusiastic, let's just say, about maintaining American democracy. Maybe things aren't as bad today as we thought they might be 2 weeks ago, but they're still not great. There's still no federal remedy for gerrymandering, for example, and much of the Voting Rights Act has been weakened. And so we need Congress to step up, and we really need to get to the point where we have a Congress that'll pass the Freedom to Vote Act, the John Lewis bill, all of that.
Absolutely. Democracy Restoration Act that certainly John, the late Representative John Conyers would perennially certainly submit, and that would restore voting rights to persons who are convicted of felonies, certainly restore their right to vote in federal elections. So there are numbers, certainly, and we need more tools in the toolbox, and certainly Congress has allowed the Supreme Court to have this outsized importance because it has refused to move on these issues. Mark, did you have a comment?
Yeah, I just wanted to put a plug in to Kevin's point about state level litigation. CLC will be arguing in Utah in about 2.5 weeks for fair maps in Utah. We filed a lawsuit challenging a pretty egregious set of circumstances there. Not only did the legislature adopt a pretty extreme partisan gerrymander that split Salt Lake County into 4 pieces, and splits one small, suburb within Salt Lake County also into 4 pieces where like you can go on a walk and you've walked through all 4 congressional districts. But they also repealed key aspects of the redistricting commission initiative that was passed by voters in Utah by a majority. Repealed the prohibition on partisan gerrymandering, repealed the cause of action to file a lawsuit challenging a partisan gerrymander, and in other ways watered down the law so that they could just go ahead and pass that gerrymander. And so we're challenging not only the constitutionality of the map under the Utah Constitution, which has many of the same provisions that you see in the Pennsylvania Constitution, for example, where the state Supreme Court there invalidated the plan, but also challenging the constitutionality of the legislature repealing this governmental reform that the people passed. The state's constitution, one of the first provisions of the state's constitution, says that all power is inherent in the people and they retain the right to reform and alter their government. A rather hollow right if the legislature can do what it did there. And so while we yearn for federal legislation, we are continuing to bring the fight to the states where we have the tools to do so.
You can see Mark is already ready for the argument.
But trying out some lines here.
As he should be. That's right. Great. So it's now time for questions from our audience. So we'll open up the floor for questions for the panel.
You seem to be muted, Gilda.
I was just talking and nothing.
I'm glad it wasn't just me.
Great. here's the first question. Post Moore v. Harper, what are the next steps for North Carolina folks to pursue fair maps? And I think we're going to start with Kevin.
Sure. So it's particularly tricky in North Carolina right now, and the little backstory is required to explain why. So while the Moore case was pending before the Supreme Court, there were important developments at the state level. Basically, the North Carolina Supreme Court had an election. Its composition changed significantly. They have partisan elections for their Supreme Court. And so it went from being a majority Democratic justices to a majority Republican justices. And one of the first things the new court did was basically to go back and repeal the old ruling that said the map that the legislature had enacted violated the state constitution. And in that ruling, the court basically said partisan gerrymandering at the state level is also a non-justiciable question. And what that means is nobody can come and try to vindicate their rights in state court due to a partisan gerrymandered map, basically echoing the same ruling that the Supreme Court issued years earlier for the federal level. So a terrible result for North Carolina voters, and one that really closes the courthouse door in any scenario. So as far as next steps, I admit I'm not an expert in North Carolina law, and I definitely defer to Mark and Paul's thoughts on this if they have any. But I would think, they might have to look into amending the Constitution, and I don't know what the processes for that are in North Carolina, but certainly something.
The process is you have to pass it in the legislature to get it on the ballot, and people have been trying in North Carolina for several years, but they haven't been able to get it through the legislature, which it right now seems particularly hostile to that kind of a thing.
Which definitely highlights the value of the initiative process in other states where voters can bypass legislatures and politicians who obviously have significant incentives not to reform systems that put them into power.
It also highlights the Freedom to Vote Act, which would create a federal cause of action, basically overrule Rucho and give you standards to apply for partisan gerrymandering claims in federal court. That's what you need to deal with states like North Carolina. They've been gerrymandering their congressional map there for more than a decade in the most egregious way. And every time they get sued, they come up with a different way to do it. And the courts just haven't been able or willing to fix it. And it's really terrible.
It is.
One thing that's interesting about North Carolina is that the governor has no role in the process for redistricting legislation there. It just becomes law if the legislature passes it. The reason that is the case is because in the 1990s, the Democrats held the legislature, and there had been there was the chance of a Republican governor, and they were concerned that they may not be able to draw districts that wouldn't survive a veto from a Republican governor. And so now here we have a Democratic governor in North Carolina who has no role in the process and a supermajority Republican legislature. So it's a item of caution to not take rash actions that you may not be able to predict the future outcomes of.
Right. Lots of issues. We didn't talk about Purcell at all, which we hopefully we might have time to get into that, because the Purcell rule was allowed for these discriminatory maps to go forward, not only in Alabama but also in Louisiana, and certainly according to the court, certainly those discriminatory plans in Louisiana and Alabama. And we see Purcell in our litigation all the time, right? That they're using, they weaponize it, right, to continue discriminatory plans. I don't know. What are your thoughts on that? And how might we get court to? Because the court essentially said my bad in the Milligan case, which is like, my bad. Oh, you had an election under this discriminatory system.
It's an apt name of the case for that. So I think one thing that Justice Kavanaugh was the deciding vote on the stay, and he sort of erected this standard he proposed of, I forget the exact words, but there had to be like a very clear case to overcome Purcell in election law. I wonder, now that he has joined Chief Justice Roberts and the other three justices in saying very clearly what Section 2 requires, if the next time one comes up that follows that standard exactly as they said was the case about the Alabama decision that will satisfy Justice Kavanaugh. But it is a very difficult area to litigate in, because particularly this decade, in which there was such a delay with the census data, the window to file a lawsuit and get relief in time for the election it turned out impossible. I'm not sure we saw any 2022 relief.
This Purcell doctrine is such a vague concept that it becomes manipulable by the courts to reach the outcome they want to reach. And the problem in part is the decisions tend to be on the shadow docket or emergency orders. The law doesn't get developed in a coherent way. And so which case is too late to be litigated and which one isn't is not consistent. And you have to worry that judges are just using it as a way to avoid having to decide things they don't want to reach. It's really an unfortunate mess, frankly.
And it's certainly been used to disadvantage voters, which is certainly something that needs to be looked at. Do we have any other questions from the audience? Okay, here's another question. What do you think of blue states drawing congressional maps on the basis of national partisan fairness, drawing gerrymanders that counteract the national partisan bias? Who wants to take them?
So that's a complicated question. The argument, as I understand the question, is it justified for blue states to have pro-democratic gerrymanders to try to create a House of Representatives, which as a whole represents the national partisan split, which is, kind of close to 50% in the country, where the House typically ends up being unbalanced in favor of the Republicans, even leaving aside gerrymandering because of the way Democrats are maldistributed in places like New York. And, I guess my sense of this is it's probably a bad idea to encourage states to gerrymander themselves and use the justification of compensating for other states. I think it's just better to have each state try to reach the fair outcome within each state. That would be my view. I don't know, others might disagree about that.
Part of the job of a member of Congress is to represent people, constituents, and to do things for communities and to respond to cities who have needs when there's natural disasters, to be sort of the point person for a particular city. And gerrymandering is bad, not just because it distorts the partisan makeup of Congress, but because it distorts representation of voters and communities and community leaders. And so I just, as a general matter, don't think that we get anywhere by encouraging gerrymandering anywhere.
Great. And I think the premise of the question is also, it's like they're making assumptions that that's why these districts are being drawn, as opposed to maybe those are the fair way to draw the maps. I know, Kevin, you wanted to add?
Just that I agree with all of that. I mean, when drawing lines, states should be thinking about what's best for their voters and not partisan interests.
Okay, great. I don't think we have any more questions, and we're near the time for us to end. So I want to give the panel a chance to, now before we certainly bring this discussion to a close, to leave us with some final thoughts and predictions as to how certainly voting rights will continue to shape up through the election cycle and beyond. We'll start with you, Paul.
Well, I think what this shows is that we have limitations on the tools we have available to preserve voting rights and to produce fair maps, but that tools remain in part because we had two decisions that didn't alter the status quo radically as we thought they might this year in the Supreme Court. Doesn't make up for the fact that we don't have Section 5 of the Voting Rights Act. We started with Shelby County. We should restore Shelby County. We should restore Section 5 of the Voting Rights Act when we can. We should get federal remedies for gerrymandering restored through Congress. There's a lot that needs to be done, but in the meantime, we have plenty of work to do and tools at hand to continue the fight. And one thing that history shows is if you don't keep fighting for voting rights and fair maps and democracy, then it'll just get worse. We're holding the line and trying to improve it every day.
Agreed.
I wholeheartedly agree with Paul's sentiments and would say, I think in the voting rights community, we have been used to losing ground for quite a long time. And so I think it's important to just take a moment and celebrate the fact that we had, when Milligan came out, that was a huge win. And though it should have happened the way it did, and it was upholding decades of precedent, we have seen the court throw away precedent in multiple contexts here recently. And so I think taking a moment to just, celebrate that win is important.
Kevin?
Sure. And I guess I'll just add that, all the prognosticators assumed that Milligan and Moore were going to be certain losses for voting rights advocates. And so it illustrates the value in continuing to fight even when the odds look very steep and stacked against you, and how important that is, and that it is not impossible to win important victories. And I guess I'll close with just a thought about Shelby. The thing that still sticks with me about Shelby, even 10 years later, is that I've always found it was this sad irony that Shelby was premised on this idea of equal state dignity, that the court was so concerned about the dignity of these political entities and completely overlooked the dignity of individuals and their right to vote and protecting that right. And I think that, it highlights that we need a Supreme Court that prioritizes that first.
Agreed. So I always say we have to fight to vote for the right to vote. And so certainly Campaign Legal Center continues that fight through the litigation and policies and advancing certainly the right to vote for all Americans. So that ends our panel today. But if you have additional questions or would like more information, please email us at info@campaignlegalcenter.org. Thank you again and enjoy the rest of your day. Thank you to our speakers as well.